Hi, Vuyo.
Hi.
So let's look at some of the labor laws that protect your rights as an employee. We understand, I think, the most crucial one and the most sort of prominent one being the basic conditions of employment. Can you explain what this act really entails?
So the Basic Conditions of Employment Act is an act that gives effect to the right to fair labor practices, and it further prescribes the minimum conditions of employment that must be applied by employers, thereby protecting the rights of employees.
What are the key guidelines or regulations that make up this act?
So the 6 main key guidelines are hours of work, remuneration, leave, salaries and wages, and dismissal, resignation, or retrenchment.
Okay, cool. So let's start with understanding your hours of work. So obviously, when you enter into any sort of employment contract, these are, pretty much what will be stipulated within your contract. So pertaining to hours of work, what are ordinary hours of work? Like what should you expect going into an employment contract? What are the ordinary hours of work?
So the Act recognizes 2 types. So there would be the ordinary hours of work and overtime. So the ordinary hours of work are 45 hours in any week. So we break down these hours by if an employee works a 5-day week, then they must work 9 hours. So we exclude your lunch break, which is an hour. And if the employee works more than 5 days, maybe 6 days a week, then they must work 8 hours. This also excludes your lunch break. So normally the lunch break is an hour, but by agreement, the hour may be reduced to 30 minutes.
Okay, great. And you mentioned that there are 2 components, ordinary working hours as well as overtime. What is the maximum amount of overtime per week that is sort of allowed in South Africa?
Okay, so the Act allows 10 hours of overtime a week. So an employee may work their normal hours, which is 9 or 8, depending on how many days a week they work. So you can add about 3 hours on top of the normal 9 hours. But an employee is not permitted to work more than 12 hours a day. But these hours may be extended by a collective agreement. But yes, an employee may not work more than 12 hours a day.
Okay, great. Yes. Okay, great. Before we carry on, to all our guests this morning, we will be opening the floor for questions at the end of the segment. So if you have any questions that you'd like to put forward for our experts to answer, please do so. We have an open chat box, so you can simply type your question and they will be addressed at the end of the session. So please just bear that in mind. And, this is your platform, this is for you. So make use of it, utilize it to the best. Okay, cool. Biogazi, let's carry on. And what are your rights around working overtime as an employee? Can an employer refuse to pay you overtime? And what is your recourse in that kind of situation?
Okay, so firstly, overtime is by agreement. So your employer cannot force you to work overtime if you did not agree or consent to working those extra overtime hours. And the employer may not refuse to pay you. Firstly, because you've entered into an agreement that they would pay you for overtime. And your recourse would be what you need to do as an employee is to lodge a pay query or a pay grievance against the employer with the employer, and give them an opportunity to just correct their wrongs, pay your money because it's due to you, you worked for it. And if they do not pay for those overtime hours that you've worked for, then you are permitted to go and lodge a complaint, either with the bargaining council if you are part of a bargaining council, or lodge a complaint with the CCMA for unfair labor practice.
Okay, cool. And are you entitled to say no if you are requested to work overtime by your employer? Is it mandatory, or do you have a say? Can you decline the offer to work overtime?
Absolutely, you may decline. I mean, it's overtime, but you may agree, obviously, to make extra money, but you're not forced to work overtime. You can say no.
Okay, great. All right, so now moving to the second sort of element or regulation under the Basic Conditions Employment Act would be remuneration. So this is obviously, I would say, the highlights of any employee entering into a work agreement. What is the national minimum wage in South Africa for you guys?
The national minimum wage has gone up from about 20 rand. Currently, it's 21 rand 69 cents. So it is criminal for employers to pay below this hourly rate. So they have to pay 21 rand 69 cents per hour or more.
Okay. And if they are being underpaid, what recourse can you take? Are there governing bodies that can assist an employee if they are being paid, below minimum wage?
Yes, they can report to the Department of Labor, or they may also lodge a complaint with the CCMA or the Bargaining Council.
Okay, great stuff. And what are the requirements for employees who maybe work on, a Sunday, they work at night, or they work on public holidays? Is there, like an extra incentive or extra wage that they are entitled to?
Absolutely. So employees that ordinarily work on a Sunday, then they have to be paid 1.5 times their normal wage. But if you occasionally, by request from your employer, occasionally work on a Sunday, then you have to receive double pay. And if you work at night, 6 to 6, so that's 6 p.m. to 6 a.m., then you are entitled to a night allowance, and your employer must provide you with transportation. And if you work on a public holiday, then you are entitled to also be paid a double rate. But if the public holiday is on a work day, then the employee must be paid their normal wage or salary by their employer.
Okay, great. And then moving on, I want to discuss leave and your entitlement to leave as an employee. Firstly, let's start with looking at the different types of leave that are available to an employee. Can you tell us what are the different types of leave that are available?
Okay, so we have annual leave, sick leave, study leave, and family responsibility leave. So with annual leave, an employee is entitled to 21 consecutive days of paid annual leave. So we know that annual leave accrues So every 17 days that are worked by an employee, you are entitled to 1 paid annual leave. But if you work a 5-day week, then the total of days in a leave cycle is 15, also accrued. So in a single month, you will be entitled to 1.5 days. And then we come to sick leave. So an employee is entitled to 6 weeks of paid sick leave in every 3-year cycle. So that's 36 months. But in your first 6 months of employment, you are entitled to 1 paid sick leave day after having worked 26 days in a month. So it also accrues in your first 6 months of employment. And then we come to study leave. So study leave, labor legislation does not recognize study leave. So you are not entitled to study leave as per the Basic Conditions of Employment Act. So it's by agreement between your employer. They have a discretion whether to give you study leave, but they may give you 3 days of study leave, especially if you are studying something that is in line with your career plan. And then we move on to family responsibility leave. An employee is entitled to 3 days family responsibility leave in a year, but only if your child is born or sick or there's a death in the family, but only if it's your mother or your grandparents, your child or your grandchild, or your siblings that have died. Then you are entitled to your 3 days of family responsibility. No aunts, no nieces, just, mother, grandmother, child, grandchild, and your siblings. It can be adoptive parents and adoptive children as well.
Okay, great. And I know that recently they've also extended paternity leave. Can you tell us how long that entitlement is?
I'm not sure. I think it's 3 days as well, but I'll have to just check and just be sure about paternity leave.
Okay, great. And is an employer allowed to decline new leave for any reason whatsoever?
Yes, they may decline, especially when it comes to family responsibility leave. If your aunt dies and you apply for family responsibility leave, of course your employer is going to decline. They may agree, but they may want proof, for example. So if you say that your aunt has died and you are the eldest in the family, you have to be there, then the employer is entitled to ask for proof, maybe like a death certificate, to prove that indeed your aunt has died. But if you have leave days available, you may use your annual leave days, but you have to get consent from your employer first that you can use your annual leave days.
Okay, great. Right, and then moving along, let's look at salaries and wages. Can we discuss deductions and, any other acts that are involved concerning remuneration?
Okay, so basically what employees and employers need to know is that you may not deduct from an employee's salary without their consent, for example. So there are statutory deductions that have to be deducted from your pay, which is your UIF, your pay as you earn, as well as deductions permitted by a court order. For example, maintenance or garnishi orders, and then the employer may deduct from an employee's salary.
Okay, great. And can you please give me an example of what a lawful deduction would be?
Okay, so a lawful deduction will be, yes, your UIF, pay as you earn, garnishis, as well as trade union subscriptions, or bargaining counsel, subscriptions, as well as medical aid. Or if you have taken a loan with your employer, then he's entitled to deduct, but as agreed between the two of you, that he would, for example, deduct 500 Rand, and then you keep deducting as installments until the entire loan is paid up.
Okay. And what are some unlawful deductions that we need to be aware of?
Okay, so for example, if I work at a till at a supermarket, then there's a shortage at the till. My employer is not allowed. He's not permitted to deduct from my salary. Also, if, for example, I break a work laptop, my employer is not allowed to deduct from my pay unless they have followed, for example, a fair procedure to determine that indeed I was negligent, and I was at fault, and therefore I am liable to pay to have the laptop replaced. Then they may deduct. But I have to give consent first.
Okay, great. Now, Virazi, let's look at workplace discipline. Can you take us through what disciplinary action entails?
So disciplinary action is a corrective procedure when an employee, for example, has committed misconduct or they are performing poorly at work. If, for example, I have committed misconduct against my employer or I've breached a workplace rule, then I may be subjected to discipline or corrective action by my employer. Also, I may be disciplined for poor performance at work, but an employer is not allowed or permitted to follow a disciplinary action. How do I want to make an example. So if I am performing poorly at work, my employer is not supposed to serve me with a notice of disciplinary action, with charges, etc. He must, follow a process where he counsels me. So call me if it's my manager, he must call me into his office and just counsel and find out what the problem is, and then they must try to assist me, to improve my performance. But if I breached a workplace rule and I've committed misconduct, then my employer is entitled to discipline me and hold a disciplinary action or inquiry just to I just went blank. Just to basically try and correct, my misconduct or the breach of the workplace rule that, I may have breached.
Okay, great. And then looking at some of the, procedures around resignation, dismissal, as well as retrenchment, what process should an employee follow should they wish to resign from their job?
Okay, so firstly, the first thing that an employee needs to do is to basically consult your contract. It will give you guidance on what to do before you resign. So if you worked for your employer for under 2 months, for example, then you have to give 1 week's notice. If you've worked for less than 6 months, but more than 2 months, then you have to give 2 weeks notice. But if you've worked for more than 1 year, then you have to give 4-week notice. And if you do not do this, then you are in breach of your contract.
Okay, great. And tell us, what recourse can an employee take if they are dismissed from work?
Okay, so obviously this will depend on the fairness of the dismissal. So if the dismissal was unfair, meaning substantively unfair, that would mean that the employer has no valid reason to dismiss you. then you can lodge a complaint with the CCMA. And also, if the dismissal was procedurally unfair, meaning that your employer did not take the right process, they did not hold a hearing, they did not bring charges and give you an opportunity to respond or rebut those charges, then the dismissal is unfair. Then you may also lodge a complaint with the CCMA or bargaining council against your employer.
Okay, great. And then lastly, Vuyo, I've heard of a term called constructive dismissal, and I'm not too sure what that means or what it pertains to. Can you break it down and explain what is constructive dismissal?
Sure. So there are instances where you may find that your workplace is toxic, the environment is toxic, your boss is just making it intolerable for you to continue working, or maybe he's or her, they are harassing you sexually or in other ways, and you feel that you cannot continue working at that place anymore, then you may resign. So this resignation is referred to as constructive dismissal. But you need to remember as an employee that you bear the onus of proving that the workplace was indeed intolerable for you, that you could not continue to work, because, you know, whoever alleges must prove. So the employer does not bear the onus, you do. And you may lodge a complaint at the CCMA if you have resigned in that manner and you were constructively dismissed.
Okay, great. Thank you so much, Vuyo. I'm going to move on to Natasha. Hi, Natasha.
Hi, Buhle. How are you?
Hi there. Awesome. Thank you. So now we've gone through the basic conditions of Employment Act. We understand the different components and the regulations under that. Now I want us to look at dealing with grievances and disputes within your work environment. Can you explain to us, Natasha, what is a formal grievance procedure that someone can undertake if they, you know, are not happy with their working conditions or any sort of dispute that may arise within your workplace?
Okay. The moment an employee suffers grievance, for example, maybe they're being forced to do some work they're not supposed to be doing, or they're not happy with the co-worker, what they need to do is put it in writing. That is the most important thing. This protects you because it's going to be needed at the bargaining council or at the CCMA as proof that you tried to resolve the matter internally. So the first step is putting it in writing. You give it to your manager or your HR. And once that has been done, so if it's against a co-worker as an example, what will then happen is the HR or the manager will then call in that employee that you're complaining about, and that employee has a right to represent themselves and to advise on exactly what, to give their side of the story. So that's when the investigation process starts. And the HR or the manager will then investigate what this grievance is all about, do a fact finding, because you need to get all the facts from both sides. And then once that is done, you will then call the aggrieved party and ask them, what is it that you want to get out of this grievance? What are you looking forward to? What solution is it that you need from this grievance? And once that is done, with all the evidence in front of the HR or the manager, the next step is that they need to assess everything and make a decision. Once a decision is reached, they will inform the complainant, which is the aggrieved party, that this is the decision we've come with. And this decision needs to be in writing, where you can say, okay, we have looked at your grievance. We are going to throw out the grievance, or we are going to uphold it or partially uphold it. And reasons need to be given as to why the employer has come up with that decision. So if they're going to uphold it or partially uphold the grievance, they need to state what exactly are they going to be doing regarding that grievance, if it's against the employer, if it's against the co-worker, or for example, if it's regarding an illegal deduction of salaries. So they need to state what exactly is going to be, what recourse that they're going to do regarding that grievance. But if the employee is not happy with this situation, they can then appeal. When they appeal, so what happens is normally it will start with maybe a junior manager. So now a second manager who's a senior manager is the one that's going to look into it and assess, depending on all the information. They'll then assess everything. Once they've assessed, they will then inform of the outcome. And if the employee is still not happy, they can then refer to the CCMA or the bargaining council within 90 days of knowing that this grievance has not been resolved.
Okay, great. Thanks, Natasha. And if it gets to a stage where there needs to be maybe a disciplinary hearing put in place, can you take us through what steps should be followed in order to facilitate a disciplinary hearing and for everything to be done legally, according to the law?
Okay. When a disciplinary hearing takes place, it means that the employer has lodged a complaint against an employee. And in this case, it means that they've breached the code of conduct of the company. It's important that all companies have a written down code of conduct and what disciplinary action is taken when an employee breaches one of those rules and regulations of the company. So once that has been done, you need to inform that employee that has breached the code of conduct that you are going to be taking them for a disciplinary hearing. You need to do this not by word of mouth, not by a WhatsApp message or an SMS. It has to be a notice. And this notice needs to state the date of the action that you're saying you breached, the date, and also it has to give the full details of when the disciplinary hearing is going to be taking place and where exactly it's going to take place. And also what also needs to happen is you need to tell them what the charges are, so that with this information, the employee can prepare for the disciplinary hearing. You cannot just say to an employee, we are expecting you on the 2nd of June to come for a disciplinary hearing. They don't know what it is about. So you need to give them the charges there, and it needs to be clear. And also they need to be given a chance to state, to bring an interpreter as well. So it has to state that you can bring an interpreter if you need an interpreter, but we need to inform the employee of this as well. And also the most important thing is you need to give the employee time to prepare. So what you need to do is you need to give them at least 72 hours. You cannot just say, you are expected tomorrow for a disciplinary hearing, and that's it, because there's no time to approach their trade union if they're a member of a trade union, or to get a co-worker to represent them, or to get witnesses to come and assist in the hearing, or to get or for them just to gather the evidence if they're going to represent themselves.
Okay, great. And now I know that there are two types of disciplinary hearings. You may have a formal hearing or an informal hearing. Can you take us through what the difference is between the two?
Okay, with the formal hearing, that's when you're given the notice that has the dates and the charges, and then you need to come in. And on that date, it's important that the employee does pitch up for the hearing, because you need to take note that if you do not come, what will happen is the hearing will continue with or without you there. And you need to have a valid reason as to why you're not able to come. For example, you can bring a doctor's note. You can send a doctor's note to your employer, your HR department in this case, and just tell them that, look, the disciplinary hearing is on the 3rd of June. I'm not able to attend because I'm sick, I'm not well, and the doctor has given me days off up until the 10th of June. So that would be a valid reason, but not to just say, look, I'm not coming. That is not going to work. And then once the hearing takes place on the date, at the said place that is going to take place. The chairperson that is going to be leading the hearing needs to be someone who's impartial, who's ready to listen to both sides and not just the employer's side. So the chairperson is going to ask the employee how they plead, guilty or not guilty. And then once that is done, the employer who's laid the complaint is going to then need to advise exactly on why they've brought this charge against the employer, against the employee. And once that's been stated, the employee is going to be given a chance to bring their witnesses, if they have any, their evidence, and why they are, if pleading guilty, or if they're not pleading guilty, why they're saying that. So they need to be given a chance to state their case. That's the reason why there is a formal disciplinary hearing. Once that is done, the employer is going to also be invited to give reasons as to why these charges should be upheld. So they're looking for reasons why. In most cases, when there's a disciplinary hearing, it's because the code of conduct has been breached and it's serious. Let's say maybe if you're driving a truck, you've been speeding, you're doing above, let's say 80 kilometers, and you're doing 120 when you're not supposed to. So the employer is going to bring in evidence to say, no, this person needs to be dismissed. And the employee needs to give evidence on the reasons. These are called mitigating reasons from the employee why they should not be dismissed. Maybe they were overtaking and they had to increase speed and things like that, or they've got a family, or they've been loyal. Those are some of the reasons that the employee can be providing to the employer. And at the conclusion of the disciplinary hearing, the chairperson will have gathered all the effect finding, the evidence, everything. And it's very important that they inform the parties that I will get back to you. They can say maybe in 5 days or maybe in a week's time while I assess everything. Once that has been done, what will happen is the chairperson has to put it in writing. Their findings. Are they dismissing the person? Are they going to be given a first warning or a final written warning? And all this needs to be in writing. And they do need to state, this is when we have the disciplinary minutes, the disciplinary hearing minutes. So everything has to be in a chronological statement when it's stated. So because it's going to be needed at the bargaining council or the CCMA if it goes that way. And then also once that has been done, the chairperson has to give the employee a chance to appeal. So they will state that you can appeal within 72 hours or you can appeal within 5 days. And the appeal has to be in writing. And also they have to also inform the employee that if you're not happy with the outcome, you then need to proceed within 30 days to the bargaining council or the CCMA. That is what the informal procedure is. And then with an informal one, it's, for example, where it could be something that is very minor. And the HR or the manager can just sit down with the employee and tell them that, look, you've breached this. For example, yes, late coming is very serious, but maybe it's the first time someone has been late by 2 minutes, as an example. And the HR or the manager will say, look, you were late, but going forward, you shouldn't be late. You know, in terms of your contract, you're supposed to be on time. You're supposed to start at 8:30. We're going to give you a verbal warning, or we're going to give you a first written warning. So that's when it's informal, but it's important that the employer does put it in writing. As much as it's informal, or discussions are supposed to be kept in a file of the employee.
Okay, great. Thank you for that, Natasha. So now let's look at what if things get out of hand and they escalate to a point where a grievance or a dispute leads to a strike or even a lockout by the employees. Let's look at, the legal rights and consequences around that. Firstly, what is a strike?
Okay, what a strike is when employees stop working or they're gonna go slow. They're supposed to produce maybe, let's say, maybe they're supposed to service 50 clients a day, but now they're servicing 5 clients a day. And then So that's a go slow, or they cause the disrepute in the company, because some people might want to strike, some people might not want to strike, and then they go and interfere with those that are carrying out their duties. So a strike happens when the employees put down their tools, and this normally happens because there is a disagreement between the employees and the employer. For example, some of the basic conditions of employment, as we was mentioning, maybe there's a dispute about a contract. The employer wants to force employees to sign a contract, change the terms of conditions of a contract, or wages, or leave, or anything like that. So that's when a strike happens.
Thanks, Natasha. And then on the flip side, can you take us through what a lockout is?
Okay. A lockout is the opposite of a strike. The strike is done by the employees, and the lockout is done by the employers. So what happens with the employer? There will be a dispute as well. So it has to be of mutual benefit to both of them. But what happens is the employer shuts out employees. For example, if you are a truck driver, as an example, you're taken out of the truck because you probably refused to change your conditions in your contract. We've had cases where, for example, you've been earning a basic of X. Suddenly, the employer wants you to now start earning by the load, and you see that it's a disadvantage. And in terms of the law, they cannot force you to accept that. So they wait for you somewhere while you're driving. They will stop you, then they take you out of the truck by force until you sign that contract. This has been known to happen. Or, for example, if you're working in an office, your biometric systems are blocked, access to your computers is blocked. That is what we call a lockout. And you're no longer able to provide a service to the company in terms of your contract. That is a lockout by the employer.
Okay, and what are the consequences of both a strike and a lockout? Like, what are the long-term consequences of such actions?
Okay, what can happen is, when it comes to a strike or a lockout, if it's illegal, this is when it hasn't gone to the CCMA or the bargaining council, no due process is followed. What will happen is, if it's an illegal strike, employees can lose their jobs, and because they're not protected. And also with the employers, if they do a lockout and it's illegal, what will then happen is they can be taken to the CCMA or the bargaining council. And to stop this from happening, for example, there's a process that needs to be done. Firstly, before a lockout or a strike can be done, especially with the strikes as well, what will happen is, when there's a dispute, it's always important that whenever there's a dispute between an employee and between employees and the employer, you need to put your grievance in writing to state that, look, we're not happy. And then you state the reasons of what it is that is not making you happy, like the conditions of work and everything. Once that is done and it's not resolved internally, the first step is to lodge the grievance internally. And if that is not satisfactory, you're not happy with the outcome of that, you will then need to proceed to the CCMA or the bargaining council. Once you get to the bargaining council or the CCMA and it's still not resolved, you'll be called in for conciliation or arbitration. It's still not resolved. What will then happen is, at the end of the day, you need to get a certificate that every case that goes to the CCMA or the bargaining council, they will give you a certificate which will state the outcome. And normally in this case with strikes and lockouts, it will state that this matter remains unresolved at this date. And also, if it's within if 30 days have passed and the CCMA has not called you in, you can also get a resolution, a certificate to state that this case still remains unresolved. After that is done, you don't just not come to work. You need to inform your employer that, okay, the case was not resolved, or even the employer needs to inform the employees the case was not resolved, and you give a 42-hour notice to say we are going to be striking or there's going to be a lockout. And once that is done, then the legal protected strike starts. and people don't need to go to work. It is protected and you cannot get dismissed for that.
Okay, great. Thank you so much, Natasha. I'm going to move over to Kayagazi. Hi, KK.
Hello, everyone. Hello.
Hi, KK. So now we've dealt with, handling disputes and grievances internally. And Natasha just mentioned that one of the organizations that are available to assist with employee and employer disputes is the CCMA. I'd like you to firstly explain what the CCMA is as an organization, KK.
All right, then. The CCMA basically is an independent body. It was created by the Labor Relations Act. They also mentioned the Bargaining Council. So that's an alternative body as well, where labor disputes can be resolved. So they both were created by the Labor Relations Act, these bodies. With that being said, they are designed to try and resolve work disputes, promote fair work practices at the workplace, as well as they provide advice and training on labor relations, but they don't merely focus on individual employee rights, like my colleagues mentioned earlier on the strike and the lockouts issue. So they can intervene in strikes and lockouts where you need the consent there to continue with the strike or the lockout, so basically.
Okay, great. And if I have been unfairly dismissed and I want to, take my case to the CCMA, what are some of the requirements of, any sort of case that you're taking to the CCMA? What do they look at in terms of being unfairly treated?
Okay, so like Natasha mentioned earlier on about the grievance process and whatnot, that you need to have your things in writing, that you were unhappy about a certain thing, like Vuyogazi mentioned, the constructive dismissal, that it's your honest to prove that you were unfairly dismissed in that way. So with that being said, you must show that you followed the process. So your reasons for dismissal, like she said, would either be based on the fact that the dismissal was substantive, in that the content and the reasons behind your dismissal were unfair, like they mentioned, the disciplinary code of conduct, if it was breached, does it elicit a dismissal and all of that. So you look at the substantiveness of that as well as the proceduralness. Do they go through the disciplinary hearing process? So one needs to look at those things before referring a matter there, so to determine its unfairness. If it's automatically unfair, you can report it to the CCMA or the bargaining council. So there's different bargaining council depending on your in the industry that you work in. So if you're in the public sector, you'll be subject to different bargaining councils depending on your profession. So one would need to maybe look into their pay slips, like Vuyogazi mentioned, the legal deductions, the levy for bargaining council and all of that, to determine where your specific matter can be reported to. So if you don't form part of a bargaining council, you can then refer it to the CCMA.
Okay, cool. And besides unfair dismissal, what other disputes can be referred to the CCMA? Can you give us some examples?
So you can report to the CCMA an unfair labor practice. I'll refer to my colleagues' contentions earlier about the fact that you've been treated badly at the workplace. The matter remains unresolved, but you haven't resigned. But now it remains unresolved. You're not getting any remedy in the workplace. So you can refer an unfair labor practice in that way. You can also refer an unfair promotion or a demotion. You've been applying for a promotion, for example, and nothing is happening, or you see that someone is promoted unfairly. That's an example as well as unfair discrimination, because discrimination can be fair. So you'd need to look into specifically what the requirements were with that specific matter in order to determine its unfairness or fairness. So it's unfair labor practices, promotion, demotion, as well as unfair discrimination.
Okay. And what disputes will the CCMA not adjudicate?
Okay. So when it comes to the CCMA, they won't take matters where there's a retrenchment, but more than one individual was dismissed or retrenched, and very retrenchment. So, but they will take the case initially in some cases, where for the first stage, we'll go through that at a later stage. For the first stage, conciliation, where they try and see if they can't resolve the matter amicably there. If they don't come to a resolution, then the matter would need to be referred to the labor court then for arbitration at that stage. So they won't listen to unfair retrenchments if there's no resolution. They also won't take matters of independent contractors. So these are individuals who are not considered to be employees in terms of the Labor Relations Act. So those are people that are contractors. They don't report to a manager. They don't deduct UIF, for example. Basically, you're not an employee for all intents and purposes. They won't adjudicate over matters that can be resolved or are rather covered by collective agreements. Collective agreements now are those agreements that are promulgated rather or created by the bargaining council. So they kind of differ from the normal Labor Relations Act and the Basic Conditions of Employment Act as well. So with that being said, they can intervene in some collective agreement issues, strikes and lockouts, but they won't take independent contractors. What's the other issue that they won't take? The CCMA won't take bargaining council disputes, I said, collective agreement issues, and also matters that can be resolved by an independent authority body. Yeah.
Okay. And is there a time limit for lodging a complaint?
Yeah. So there is strict time limits when it comes to referring matters to either the CCMA or the bargaining council. So when you've been unfairly dismissed, you have 30 days to report the dispute. When you are alleging an unfair labor practice, you have 90 days to report the matter, your complaint. And when it's an unfair discrimination, you have 6 months to report this to the CCMA or your bargaining council. So these time limits are strict. They include the holidays, your weekends, so you must count all the days when you're calculating your referral dates. And also, if you are late, there's also a remedy there, but it's not advisable, hey, because now the discretion is with the CCMA whether or not, or the bargaining council, whether or not to take your matter on in the first place now that you're late. So you need to provide reasons for your lateness. The degree of lateness is also important. How late are you? It won't be reasonable if you're late for almost more than a year and you don't have valid reasons for your lateness. So they will assess your application for condonation. That's what the application is called. So you first need to apply for condonation. Now I'm late and these are my reasons and I'm late by this much, and I won't prejudice anyone if you guys hear my case. The employer will be able to also have their side heard, so you need to provide substantive reasons why you are late. So strict time limits, yes.
Okay, and can an employee appeal the decision of the commissioner?
Okay, so like I mentioned, the process at the CCMA has a first stage and a second stage, depending on what happens. So the first stage is basically where your employer and your employee are there, and the commissioner is a third person hearing whether or not these two parties can come to a resolution. They can make suggestions there how to resolve the matter. However, it's incumbent on the two parties to make a decision how they resolve it. So if they do resolve it at conciliation, so they come to an agreement how the matter should be resolved, they will be made to sign a settlement agreement. It stipulates how you guys are intending to settle the matter, on which dates, what must happen. So once you sign that document, you cannot make any appeal or reviews against it. With that being said, then there's a second stage. The second stage is then called arbitration. Now, with the first stage, attorneys are not allowed. I mentioned that there's 3 parties involved there. But now with the second stage, you may be allowed an attorney to represent you. You can also have your trade union present to represent you, and all of that. It's like it's almost similar to a civil process where you have opening statement and all of that, where then the final decision in that instance is then made by the commissioner there. So that decision is binding. You cannot appeal it, to answer your question correctly. So you can't appeal a decision that is made by the commissioner. You can, however, review it with the labor courts. So you can't now appeal it or review rather at the stage at the CCMA. You have to now go to the labor court to make your application for review. And your application for review would be based on the conduct of the commissioner. So was the commissioner not conducting their duties properly? So it would be misconduct on the part of the commissioner, or a gross irregularity in terms of the processes that he followed at the hearing. Did the commissioner exceed their powers? Like I mentioned earlier, they can't make decisions at the conciliation stage. So did they exceed their powers in that way? Was the award you were given, if the other party maybe wins this, the award was given, was it awarded incorrectly? Is there a defect in the documents and all of that? So that's when then you can make an application for review with the labor courts. Then the labor courts will be the ones to decide, okay, this actually did happen, and they won't hear the matter, or they will have to refer then the matter back to now the CCMA to have it heard again, maybe by a different commissioner.
Okay, great. And how can we at Legal&Tax assist our members if they are facing a CCMA case?
Okay, so our members, we always advise them to call speedily when they're facing any kind of labor issue, especially when it's a disciplinary hearing where you can see it's serious. So we provide them advice based on the law, like we mentioned earlier, on what processes to follow, and they must keep in touch with us in terms of what now is happening in the stages that they are at with their matter, so that we can then collect documents from them in order to further advise them and assess a cover for them when it comes to their matter for legal representation at any given stage, because it's not automatic, you know.
Okay, great. I have a few questions from our guests. The first question is, what happens if an employee didn't get sick till leave day circle is expired? Example, I get 32 days for 3 years, but I didn't get sick within that cycle. I'm going to direct this question to Vuyokazi.
Hi, Buhle, may you please repeat?
Okay, so the question reads, what happens if an employee didn't get sick until the leave days cycle has expired? Example, I get 32 days over a 3-year cycle. But what happens if I didn't get sick within that cycle before it expires?
So firstly, the cycle is 6 weeks paid sick leave over a period of 3 years. So if you didn't get sick, then you forfeit your sick days, because you don't have to take them. You only take them when you are sick. So it's very important. It's not like annual leave.
Okay, great. And then I have another question. It reads, in my line of work, I'm required to do certain duties during the weekend. If I choose to take a day off on Monday, am I still within the law? Vuyokazi, I'll direct it to you as well.
I'm not sure if I understand, but if by agreement with your employer, you work on weekends, because remember that an employee must have 12 consecutive hours of rest, And this must include a Sunday, unless you have agreed with your employer that you will work on weekends or on a Sunday. Then you can agree, instead of getting paid for working on a Sunday or a weekend, you can agree to take time off during the week.
Okay. I also have another question pertaining to leave. So once again, Vuyo, if you can take this one. What is my legal recourse if I could not take all my annual leave, and our policy allows 5 days to be carried over, but I had more days and my manager approved carryover, but now there is no funding and there are retrenchments looming?
Please come again, sorry.
So I think basically they have about 5 days of annual leave that had carried over, but now it seems that retrenchments are looming. So what's going to happen? What recourse can they take regarding that annual leave that was meant to be carried over?
Okay, remember that annual leave is paid for. So if you did not take all your annual leave days and you are now being retrenched, your employer must pay you for your leave days that have been carried over by agreement or were remaining within the leave cycle.
Okay, great. And then lastly, I have a question. What steps do I follow if the access to the system is taken away while I'm on redeployment and access is reinstated afterwards, after your query and the employee states there was an error? I'm not sure if...
I don't think I understand.
Okay.
So, okay, can you just please repeat one more time?
I think looking at the time also, I think that's, like all the amount of time we have to take questions. I just want to have a final word from you ladies. What is your takeaway message to our guests? Natasha, I'll start with you.
Okay, thank you. Okay, firstly, when you have a grievance, even though it's going to be an informal process, just make sure that your grievances are all recorded and you please keep a copy of that grievance. So you need to read the code of conduct, how to do a grievance, keep a copy. When you go to bargaining council or CCMA, it is going to be required. A paper trail is always important. Thank you.
Thank you. Kayagazi?
Yes, I think what Natasha mentioned is very important, that paper trail works in your favor. So really, it's always, for me, keep a good relationship with your employer if it's possible, because then you'll get ways in terms of resolving things without having to go through all these strenuous processes. But if there's any issues, definitely please call us. We'll provide you all the advice that we can.
Great stuff. Vuyokazi?
So I would say that read your contract so that you know what is expected of you. Read the code of conduct or any rule in the workplace. If your employer does not give it to you, request it so that you know exactly what's expected of you and what to do and what recourse to take should anything happen.
Okay, great stuff. Ladies, thank you so much for joining me. It's been very insightful as always. Thank you to our guests that took the time out to be with us this morning. And if you have any queries and you'd like to speak to a legal advisor at Legal&Tax, please do call us. Our number is 0860 587 587. You can also our experts here at Legal&Tax. Thank you so much, KK. Thank you, Natasha. Thank you, Vuyokazi. And until next month's edition, I hope that you will, keep in touch with us. Let us know if you have any issues and you'd like to speak to an expert. Thank you so much once again, and I'll see you in next month's edition. Thank you so much. Bye-bye.
Thank you. Bye.
Thank you.
Cheers. Bye.